Before I rest, I wish to make it clear that in our constitutional dispensation, care must be taken not to create a statutory institution without checks by the court on how they deal with the citizenry. Failure to hold them in check will be a throwback to the era of unlimited executive powers, which will certainly undermine our democratic dispensation, end quote. What are your own views on this matter as you rise to the highest court?
I think I see this as anchoring in the doctrine of separation of powers and the court having the duty to interpret law and be more or less as a watchdog or the guard against excesses. Of course, the court ought to recognize its duties and its functions. So that statement is profound based on the fact of the case as dealt with by Ackaah-Boafo JSC. Many times, some of these cases come up, and I think if the occasion arises to re-echo such words, or as part of our education, that will be done. Thank you.
What about looking at it in the context of human rights? Looking at this statement in the context of human rights, have you any views on?
Well, I think with the greatest respect, we sometimes bandy things around as human rights, such that anybody at all sometimes will raise certain issues to say that it is my right. But we must always look at Article 41, I think it's in the K or J, which talks about the rights and the responsibilities. If the Attorney General, the prosecutor, has a role to play, and he says, I've investigated the matter and I'm providing information to the public, I think, as I've already said, that may be within the mandate. But anything else that may go on to prejudice the trial, certainly if the occasion arises, can be dealt with. Thank you.
But you've already indicated there's a thin line, correct?
Yes.
Very well. My Lord, let's deal with some food you have already served the judiciary. You've cooked something. In your concurring opinion in the matter of Ackaah-Abubakar, alias Raga Jiwa versus the Republic, decided on 27 March 2025, as well as broader constitutional and legal frameworks governing arrest, investigations, due process, and personal liberties in Ghana, there are some few things that I would want to bring to attention for your views on. I must say that these would further be anchored on Articles 14, 23, our Criminal and Other Offences Act, and of course, ethical standards for law enforcement. Now, at page 20, paragraph 25 to 26, these were the very veritable words you used, and I quote, "My lords, another aspect of this appeal on which I wish to express my opinion concerns the reason for the appellant's arrest in the first place. In my view, this case, like a few others I have had the opportunity to review, presents and reveals a troubling trend in the manner in which investigations are conducted by the police and prosecutions are carried out in our courts. In this case, I question why the appellant was arrested, as the record of appeal reveals that, apart from the statement of persons arrested alongside the appellant, who indicated that he was part of the robbery, no independent evidence linking the appellant to the robbery was obtained by the police." You further went on at paragraph 26, and these were your words. Quote, My lords, in my respectful opinion, the time has come to be blunt with investigators. Arresting an individual solely based on another person's statement without a thorough independent investigation poses significant risks. Apart from the obvious ethical lapses inherent in a laissez-faire attitude towards investigating accusations, the accuser may have personal motives such as revenge, bias, misidentification, or even deliberate deception or deflection of attention from actual perpetrators, leading to wrongful arrests. Moreover, such practices encourage arbitrary policing, fostering abuse of power, and the erosion of public trust in law enforcement. They also create opportunities for individuals to manipulate the system for personal gain, using arrests to settle scores, eliminate rivals, or shield actual perpetrators. It is imperative that investigators recognize the necessity of conducting proper investigations supported by corroborating evidence such as forensic proof, surveillance footage, and credible eyewitness testimony to mitigate this risk and uphold justice, unquote. My Lord, from what you stated in your concurring opinion, you criticize the police for making arrests without independent investigation. What, in your view, are the constitutional obligations of investigators before depriving a person of their liberty under Article 14, respectfully?
Thank you, Mr. Chair. I think my view is rightly captured in the dictum you read out. I am of the view that, and as I indicated in that case, the record reveals that apart from those who arrested with him saying that he was part of us, there wasn't any investigation that was conducted to link the individual. And these statements were actually even not repeated in court, apart from caution statements. So that is where the statement comes from. My view is that there is a need to have proper investigations and not a co-arrestee say so be the basis for prosecution. Thank you.
Lord, flowing from this, you, like, as you've already indicated, you've warned against arresting individuals solely based on statements from co-accused persons. How then should the judiciary guard against arbitrary arrests that are used to settle personal scores or suppress rivals? How should the judiciary boldly confront this to guide our democracy and the rule of law?
Thank you, Mr. Chair. I think it depends on what stage we are at. If an investigator comes to court and said, I've done this investigation, I arrest somebody and put a person before the court, I think at that stage it will be difficult for a court of law to say that at that preliminary stage there's no basis, let him go. The only way the judiciary can confront this is when presented with the compendium of evidence, assess it, and say that there wasn't no basis for this arrest and no basis for the prosecution. So, and I think we've done so far. We've done well so far when it comes to such things. If ultimately there's no evidence, there's no evidence. And the court makes a decision. Thank you.
Lord, now you are going to the policy court where you will want to propose reforms. So let me ask you, it's a court of liberty. Nobody would be up to be checkmating unduly, except perhaps, of course, the matter comes up for review, or long after you've left, a new panel comes up with a new view, which is the case in our courts. But for the time being, you've described this laissez-faire attitude in policing as a threat to public trust, and I agree with you. What, therefore, in your view, should be the legal or institutional reforms necessary to ensure investigations are thorough, ethical, impartial, and conclude in good time.
Thank you very much, Mr. Chair. I think I would take a cue from my last answer. If until matters are filed in court, based on our rules, based on the laws in the country, I think the court will have very limited role to play until matters are filed. So that these guidelines ought to come from the Ministry of Attorney General and the prosecutorial services to guide this. But we know we also have matters of delay in our rules. In other jurisdictions, they apply so well where no matter the charge, it could be stayed if the matter has been unduly delayed. So these are things that we can have conversation about. Should somebody stand trial for 5 years without calling any evidence? These are conversations that we can have, but I'm not sure at the investigative stage the court will have much to do until matters are filed. Thank you.
My Lord, the police prosecutor comes to your court, says that a big man, a businessman, has reported of stealing. The stealing was a check. That, of course, he signed a blank check. And the houseboy tore it from the checkbook, went to cash it from the bank. When this boy was arrested, we are told that he confessed as having tore the check leaflet from the book and indeed cashed it. The police is so clear that he has satisfied the essential ingredients of stealing. But emphasis is that the money was taken from a bank account. My Lord, in a situation where the bank account itself is not provided, the bank statement is not tendered, yet prosecution tells you that before an independent witness, the accused confessed the offense. In your view, in that circumstance, would all the ingredients of the offense in the circumstance would have been met?
Thank you, Mr. Chair. And on this confession statement, if we look at Section 120 of the Evidence Act, is the accused admitting that indeed I made a confession, or is the accused challenging the alleged confession? I think that is the first part to deal with. The next part, again, the judge will have to look at the ingredients. If the non-provision of the bank account or the check clearly does not meet the standard, the court will have to rule that the standard has not been met.
So, my Lord, in a situation where the caution statement was properly procured, so the independent witness, yes, it is true that it was properly procured, but the bank statement of the businessman, which bank statement would show the withdrawal with dates and all, and the name of his houseboy is absent. The entire bank statement is not before you. Would you consider the confession statement as sufficient to say the gentleman is guilty, as prayed by the prosecution?
Mr. Chair, my counter question is, if indeed by Section 120 the accused there's no problem about a confession, then the question, what did the accused confess to? Did the accused because the fact ought to be explained. The man says, I stole my boss's money. Is it a position that after that confession, the person understanding all the facts that led to him being arrested and providing this, in the face of that confession, the absence of the check and the bank statement should be thrown out? I think depending on the facts, if these are all the facts, I think the confession statement
but my lord, in Tagore, the Court of Appeal was very clear that no matter what the accused says, the requirement to lead evidence on all the essential ingredients of the offense must not be compromised to the extent that the accused comes into the box to say, I'm not guilty. Do you have some disagreement?
Not at all. I mean, I am a consummate jurist on meeting all the ingredients. If the ingredients have not been provided by the prosecution will lose. So that if in this situation, the non-provision of the check and the statement, which will all establish the fact that this is how it was taken, are not there, clearly my decision will not be conviction. Thank you.
So, my lord, to conclude on it, and just to guide your juniors and all of us students of law and practitioners, situations where confession statement has been procured properly, no doubt on it, it's not in question. But in the box, the accused now says, I'm not guilty. You are saying on oath that going by Tagore, all essential ingredients must be proven, correct?
The law is that all essential ingredients of a charge must be established. If it's not there, and the person, I mean, when the person mount the box and say, I'm not guilty in the face of the confession, then that person will have something to say. But even in the absence of the person saying something, by pleading not guilty, he or she has thrown the gauntlet at the prosecution, prove it. Okay? By the person saying, I'm not guilty, the person has basically challenged the prosecution to prove the ingredients. And if the prosecution has not been able to prove the ingredients, the decision will have to be made.
Very well. My lord, now, as part of reforms, you are going to a court that undertakes reforms that helps shape public opinion and all. Do you think that there should be a minimum evidential standards to be met before lawful arrests? Do you think?
There should be a minimum what?
A minimum evidentiary standards to be met by investigators before lawful arrest.
Mr. Chair, my view is that before the police arrest someone, they ought to have some evidence for arresting the individual. And that would tailor in with your use of minimum evidence. Because I do not think that anybody should be arrested when there is no evidence for arresting that individual.